Welcome, everyone. We're just going to wait another minute to let our participants populate into the webinar, and then we'll get started. Okay. Good morning, everyone. I'm Chris Lindgren with MassBio. Thanks for joining us today. I want to thank our speakers for their generosity. Also, I want to acknowledge and thank our legal co-chairs, John Harry of Mintz, Lana Gladstein of Arata Bio, Matthew Carlin of Morrison & Forster, and Dan Shores of Rothwell Fig. Please use the Q&A function at the bottom center of your screen. Just click on it, it will open and you can type in your questions. You can do that at any time during this forum. The chat is available to you, but please use the Q&A for questions. And with that, I'm going to turn it over to our moderator, Dan Shores of Rothwell Fig. Thank you.
Good morning, everybody, and welcome. I'd like to also welcome everyone to today's webinar, Understanding President Trump's Proclamation, Limiting Immigration and its Impact on the Life Sciences Industry. I'm Dan Shores. I'm a partner at the law office of Rothwell Fig here in Boston. I serve as a co-chair for the MassBio Forum's legal working group. And I'm an IP lawyer, and I work with a lot of life sciences companies to help those companies protect their innovations and to forge constructive commercial partnerships. And while I'm certainly not an immigration lawyer, I'm pleased to moderate today's panel on this very important topic. I've learned a lot, especially from our esteemed panelists here during this process, and I hope you do as well. The purpose of today's webinar is to, number one, provide the MassBio community with an overview of the June 22nd proclamation that suspended the ability of certain foreign nationals to enter the United States on certain visas through at least December 31st of this year. We also want to explore the types of visas that are affected, the exceptions of who this applies to and who it may not, and then how in general this proclamation may affect you and others in the MassBio community. And then we'd also like to discuss the future of the proclamation, the scenarios that the MassBio community may consider with respect to the proclamation going forward. I want to thank Chris Lindgren and all the others at MassBio for their extremely hard work, obviously throughout the year, but also in assembling this great panel of experts we have. And indeed, they are a great panel. We've worked very hard in advance of this to provide you with as much information as possible in the short time that we had. And with that, I'd like to introduce our panel, and then we'll get into the topics for discussion. Here we have Keith Pabian. He's the founding partner of Pabian Law. It's a national immigration law firm headquartered in Massachusetts that focuses on assisting employers through the visa and immigration process. Keith has extensive experience working with organizations and individuals in the life sciences and biotech industry, both in the Boston area and around the country. He regularly presents at national conferences, industry meetings, and on webinars on employment-based immigration topics and opportunities. He's also appeared in numerous publications and in the media to discuss immigration issues and topics affecting the foreign national workforce in the United States. He's received numerous awards for his success in providing solutions to employers' most pressing staffing issues. He's an alumni of Villanova University School of Law and Union College, and he lives in the Boston area with his wife and two elementary school-age sons. So that's Keith Pabian. Next we have Bennett Savitz. Bennett has practiced exclusively in the area of immigration law since 1994. Since 2008, Bennett has been selected as one of Boston's best lawyers in immigration law by Best Lawyers of America. In 2018, his firm, Savitz Law Offices, was selected as the Massachusetts Business Immigration Law Firm of the Year by M&A Insider Awards, and Mr. Savitz was selected as Immigration Lawyer of the Year in Massachusetts by the International Advisory Experts and Corporate Livewire. Since 1994, Bennett has been an active member of the American Immigration Lawyers Association. He served on several local and national AI/LA committees, helping shape policies and procedure for the entire immigration bar. He's currently teaching immigration law at the New England Law School and a graduate course on immigration in immigration law and policy from Lesley University. Last but certainly not least, we have Rhonda Teachen. Rhonda is a partner with the firm RSST Law Group, and she's been practicing in the field of immigration and law since 1999. Her practice is concentrated in business immigration, working closely with universities, hospitals, and companies in the pharmaceutical, biotech, and IT industries. Among others, Ms. Teachen and her team provide comprehensive employment-based immigration services, including non-immigrant visas and permanent residence through PREM labor certifications. She and her team also work extensively on non-immigrant and immigrant work visas for researchers and scientists, including L1, EB1, and national interest waiver petitions. In addition, Ms. Teachen's practice includes working with physicians on both immigrant and non-immigrant issues, including advising and overseeing J waiver applications. Furthermore, she advises clients regarding worksite compliance issues, including preparing for and conducting I-9 audits. Ms. Teachen previously practiced immigration law at large corporate law firms in Boston and Washington, D.C. Immediately prior to joining her present firm, she spent more than 3 years as part of the in-house legal department at a biopharmaceutical company located right here in Cambridge, Massachusetts, where she was responsible for a full-service immigration practice, as well as working with issues of employment law, deemed export compliance, I-9 compliance, and various types of contract negotiation. Ms. Teachen is listed in the best lawyers in America. She is an active member of the American Immigration Lawyers Association and previously served as the Massachusetts State Workforce Agency Liaison for the New England chapter of AILA. She is currently a member of the International Medical Graduate Task Force and NAFSA, Association of International Educators. Ms. Teachen is a graduate from the Georgetown University Law Center. So we clearly have some extremely qualified attorneys, experienced attorneys here to talk about this issue, and it's an honor to serve as the moderator for this discussion. So I think we should kick things off by providing ask the panel to provide an initial overview of the proclamation, to explain to our audience here what the proclamation is. And I'd like to maybe ask Bennett Savitz if he could lead that discussion.
Sure. Thank you, Daniel. Appreciate it. Good morning and welcome, everybody. So the origin of this current proclamation that we're going to talk about today actually goes back to April 22nd, when everything was kicked off by a smaller proclamation that didn't get as much press, which was for people who were not in the United States at the time and who were seeking to obtain entry as an immigrant or a lawful permanent resident, which is a legal term, or a green card, which is the euphemism. So people who are not in the United States and seeking to enter as an immigrant were barred under that April 22nd proclamation from entering the United States, with some exceptions. But the idea was that starting in April, there was this idea of barring entry into the US of certain foreign nationals. And in that case, it was immigrants. And the idea was in that proclamation that within 60 days, there would be more examination of this issue and a subsequent proclamation that would cover non-immigrants, meaning temporary entrance into the United States. And so sure enough, on June 22nd, we have the current proclamation that Daniel mentioned, which is what we're going to spend most of the time talking about, which did two things. First of all, it continued that prior April 22nd proclamation barring immigrant entrance through the end of the year. So instead of 60 days, the proclamation now is through the end of December of this year. And then the second thing it did was it added another set of bars for people entering the United States for the rest of the year. And in this case, it was targeting non-immigrants or temporary entrants. And it was targeting temporary entrants in the following categories: H1B, H2B, some J visa entrants, and L visa entrants. Now, Rhonda's going to go into that in a little more detail in a moment, but the idea is that if you're seeking to enter the US in those classifications, and that includes the principal applicant who's coming in under that classification, and dependents, which in immigration law is spouses and children under 21, that those folks would be barred from entering the US also through the end of the year. The three requirements to be barred from entering the US under this proclamation is being outside the US on the effective date of the proclamation, which was June 24th, not having a non-immigrant visa that is valid on the date of the proclamation, and not having any other travel document that permits them to enter the United States that is valid on the date of the proclamation. So I just need to define a couple of terms and then talk about who that applies to and who that doesn't based on those terms. So we keep talking about the term visa here, and it's really important that we define that because a lot of people confuse visa and status. So visa is a travel document that you get in your passport to enter the United States. So this only is a proclamation that bars people from entering the US or obtaining a visa. This is a travel-related bar. This does not affect people who are already in the United States, and I'll talk about that more specifically in a second. But the idea is that it's a visa bar because under the Immigration Act that we're talking about, the president has the authority to bar certain entrants in the interest of based on certain national security or economic extraordinary circumstances, and we'll talk about how that's really a subterfuge, but that's a separate topic that we'll get to. But the point being that this is only a travel ban. This is not to affect people who are already in the United States. So it does not include anybody who's in the US applying for any status, whether it's non-immigrant temporary status or a green card immigrant status. USCIS continues to accept and process petitions and applications for non-immigrants and immigrants, including requests to extend someone's status, change someone's status, or adjust someone's status to lawful permanent resident or green card. It also does not bar anybody who has the visa as of the date of the proclamation. And so the idea being that if you have a visa and it was subsequently clarified or amended that the visa had to be in the classification that you're seeking to enter in. So if you already have the visa in your passport in that classification, that you are also not barred from entering the US. So the proclamation does cover a lot of people, but it also doesn't cover even many more people. And so that's really important to know. And
So
then
Bennett, if I could, not to interrupt your flow here.
Go.
But so to summarize, we had these two presidential proclamations. One was in April, and the second one was in June, April 22nd and June 22nd. Now, I think we've heard a lot about in the past in the media about executive orders, and here we have a proclamation. Does Rhonda or Keith or Bennett, what's the difference between, does the proclamation have the full force of law, or is it different than an executive order?
So it's funny, that was one of the first things that we looked up because we were getting that question a lot. A proclamation is another way. It's essentially an executive order, but from my understanding, it's basically talking about people outside. But it's it's essentially a fancy term for an executive order. It's another presidential action that didn't go through like the formal rulemaking process.
Yeah, so both proclamations and executive orders are ways of the president enunciating a policy without having to go through any other process. As Keith mentioned, the only technical difference is an executive order is ordering some other agency to do something. And so because this is really just saying these people can't come in, it's a proclamation because it really doesn't order anybody else to take any action. It's just saying, from this day forward, proclaim the following. It's kind of royal in that sense, I suppose.
But is it correct that it effectively has the force of law, and it's
Absolutely.
under the sole discretion of the President of the United States, whoever that that is. Whoever
Right,
issues.
assuming that it's constitutional. So the only challenge to a presidential proclamation or executive order is to
Right.
go into a federal court and say it's not constitutional.
So this
Assuming it
is
is
a,
constitutional, then it has the full force of law in the entire United States.
right. So this is a real and existing, essentially a real and existing law that needs to be dealt with.
Yeah, and as I mentioned, this has its origins in the Immigration Act, for barring entry of people for national emergency purposes. And the reason why we know these presidential proclamations or executive orders get upheld is because as soon as Trump was elected, the first thing he did was the what he calls the travel ban, what we call the Muslim ban. And so it took him 3 tries, but by the 3rd try, the Supreme Court upheld his authority to bar entrance into the United States. And so the subsequent proclamations and executive orders have used that as a template of how to put forward proclamations and executive orders that are going to be upheld under this constitutional scrutiny. So there will be challenges to all of these, and there are legal challenges to this as well. But this administration knows how to draft these now to try to get them upheld by the court. So we'll see what happens with those challenges, but it's getting harder and harder to challenge these things.
Okay, so Bennett, you mentioned that in your overview of the proclamation, which we'll certainly get more into as we go forward here, that there were certain visas that were affected. There's certain people that are affected. There's certain types of visas, and so I wanted to ask Rhonda if she could kick off that discussion, provide an overview of that.
Sure. So I just want to provide a little information about the relevant visa types that are included in the proclamation. The first is the H-1B visa. The H-1B is the primary visa that provides work authorization for professionals. It's for specialty occupations, so positions that require a degree in a particular field of study. The H-1B is used for the whole life or research job ladder, from RAs all the way up to higher management level positions, as well as IT and other support staff. Most for-profit companies who are hiring somebody on an H-1B for the first time, and quite often this is after the individual will have worked for them for some period of time after graduation as an F1 student. Most for-profit companies have to go through the HCAP lottery because there is an annual cap on the number of H-1Bs available, and there's a lottery that's run each year. So I'm sure that a lot of our participants here are familiar with that fun process. There are organizations that are exempt from the annual cap on H-1B visas, and that includes universities and teaching hospitals and nonprofit research organizations. And those organizations can get H-1Bs at any time. And then companies also hire people who are already on H-1Bs with other employers, and then they're moving them and getting a new H-1B for them for their company. That's one category that's included. So H-1Bs and their dependents. Also included in the proclamation is L1As and L1Bs. The L1A and L1B program is for multinational companies who are transferring their personnel to the US, either as people with specialized knowledge of the company's processes and procedures or proprietary research, or as managers and executives. And this is a very important program, particularly for larger companies where this transfer of personnel has been routine for years. Either they have established secondment programs where people are moving for a year at a time, or they're really are project-based, where entire projects move, as new projects are formed, then they're transferred to the US for a certain period of time or eventually permanently. So that's a program that is going to be really affected by this. One of the things, as I mentioned about the H-1B program, is because of the annual limitation, it is really hard for employers to hire new people from outside the US and in H-1B status, because there just aren't H-1Bs available most times during the year. It's more common, I think, for companies, especially larger companies, to transfer their personnel internally throughout the year, and they have relied on this program again for a number of years. Another category that's relevant here, that's included in the proclamation, is the J1 trainee and internship program. And this really allows people to bring people on board for shorter periods of time, 12 to 18 months, as an intern or trainee. So I think companies use this for short-term positions. They also use it when there aren't other options available, when they're not able to hire a new graduate on an H-1B because there isn't an H-1B available. They can kind of use the J as a bridge until they have another option for somebody. So this is another program that has been affected. And again, it also includes all of the dependents. But I do think, as important of the things that are, the categories that are included, it's also important to note the categories that are not included, as this will help companies plan and strategize for what they can do. What's not included are O1 visas for aliens of extraordinary ability. This is also a way that companies traditionally bring people from abroad because they're available throughout the year. There is not a numeric limitation. And it's generally for, you know, PhD level researchers with a publication record and some other professional accomplishments, as well as some upper management level positions. The J1 Research Scholar program is still available, and that allows people to come into the US for up to 5 years in research positions. And the TN visa is still available. And the TN is for Canadians and Mexicans, certain professionals. There is a limited list from Canada and Mexico to come to the US. Now, interesting, Bennett talked about the differentiation between status and visa. Canadians are exempt from the visa requirement. They do not have to go to a consulate and apply for a visa in order to enter the US. They can make their application directly at the border. It appears that this makes them exempt from the proclamation in general, meaning Canadians may still be able to be coming in even in H-1B and in L, as well as TN. So that's something important to keep in mind as well.
And we've seen clients successfully, or foreign nationals successfully enter on those since the proclamation's been issued.
On TNs?
On TNs and Ls and Hs, better Canadians specifically.
I have had Canadians enter on TNs, but I haven't had Canadians enter using this kind of visa exemption since the proclamation.
We've also had Canadian H-1Bs enter. So yeah, so CBP did, Customs and Border Protection, did confirm that Canadians are exempt from the proclamation because they don't need a visa. Yeah,
so that's great.
Yeah, we had to have one guy go back twice because the first CBP officer didn't get the message, and then they went back to the same border crossing and they let him right through.
Well, I think that's you know, the undercurrent, I think, here on everything we're talking about is how it actually works in practice. And there are so many different agencies, so many different consulates, ports of entry, officers involved, that kind of predicting with any certainty how an individual is going to be treated at any given consulate or port of entry is impossible, which makes planning, even if you're eligible for an exception, makes planning very difficult.
So we've seen a lot, certainly a lot of news generated surrounding COVID, needless to say. And my sort of follow-up question back to Bennett, what Bennett had started to talk about was, how is this, how is this proclamation, this immigration restriction, immigration ban, how is that different than the COVID-related restrictions? What's the contrast with the other policies that are being implemented now relating to COVID-19?
Yeah, so that's a really good question, because this has led to a lot of confusion from not just clients, but even attorneys on how this is working, because unfortunately, because the proclamation does mention COVID, because as I had alluded to, this administration has used COVID as a subterfuge to justify the proclamation, even though there's really no reason behind it that makes any sense based on science, which I don't have to explain to this group, fortunately. So the idea that COVID is mentioned then confuses the restrictions in the proclamation with other COVID-related travel restrictions, which were already in place prior to the proclamations, have been changed subsequently and added subsequently to the proclamations. So there are many countries from which entry is not permitted at all. There are other countries where you need to have a certain quarantine, for example, certain Schengen countries where you have a 14-day quarantine requirement before you're able to enter the US. All of those are completely unrelated to the proclamation. So the proclamations stand alone, where they bar certain people from entering, and that's it. If COVID went away tomorrow, we would still have the presidential proclamation. Similarly, if the presidential proclamation went away tomorrow, we would still have the COVID-related travel restrictions. So they operate completely independently from each other, and you need to analyze both when you're trying to figure out whether somebody can enter the US.
Okay, great. We just had a question come in that related to what Rhonda was speaking about. The question comes in, it says, if someone has a J1 visa, March to July, but was unable to enter the US as expected due to COVID travel restrictions, can they extend/postpone their visa as they have not been able to get to the United States yet?
So I think it depends again on the semantics of that. So if they have a visa stamp in their passport already that was valid as of the effective date of the order, which was June 24th, 2020, if they have a visa stamp in their passport, a J1 visa stamp in their passport that was valid as of that date, then they should be exempt from the proclamation and they should be able to order or to enter. If they have been approved for J1 status, so they have their J1 paperwork, but they haven't yet applied for the visa stamp, then they wouldn't be able to, depending again on the category. What did you said that was a
J1, he said.
A J1.
J1, right.
So if it was a trainee, maybe. If it was one of the J categories, that subject, then if they don't have the visa stamp yet, then they wouldn't be able to apply for it unless they're eligible for an exception. Shall I cover the national interest waiver exception?
Let me just, actually, let me chime in with two,
Okay.
I think, important follow-ups to what you just said, because that brings up 2 points that people need to understand. So number one, getting the visa to come in isn't just simply a matter of whether you're subject to the proclamation. Right now, a lot of embassies aren't making visa appointments because of COVID. So until you can get an appointment to get a visa to come in, it doesn't really matter whether you're subject to the proclamation or not, because you still need to get the appointment to come in. So that's number one. And then number two, if you have a J1, for example, like Rhonda's talking about, you also have to make sure that the paperwork that underlies the visa is still valid. So in other words, if you're talking about postponing the entry, and your program was only scheduled to go through July, and you can't get a visa to come in, even though you're not subject to the proclamation, but you just can't get into the embassy to get an appointment for a visa to come in, you might need new underlying paperwork to be issued in order to get a visa appointment and come in, because your program is no longer valid.
Yeah, so that's how all of these things layer on top of each other. All of the problems we're facing. I did want to mention the national interest exception to the proclamation, because I think it's important. So written in the proclamation itself was the idea that a national interest exception that was available for any individual whose entry would be in the national interest as determined by the Secretary of State, Secretary of Homeland Security, or their respective designees. Okay, so that's not particularly helpful. But the State Department has clarified who is eligible for the national interest exception. So for both H-1Bs and Ls, the exception is available for a public health or healthcare professional or researcher to alleviate the effects of COVID-19 pandemic, or to conduct ongoing medical research in an area with substantial public health benefit. And they provide the examples of cancer or communicable disease research. So a researcher working in the field doesn't even have to be COVID related. So researchers working in the field of medical research can be eligible for a national interest exception. And then the State Department goes on to say that you would go to your relevant consulate and request an appointment, and then they would determine your eligibility for for this exception. So this appears to put a great big hole right in the middle of the proclamation that should allow a lot of the relevant workers we're talking about to be able to come. But again, this is on paper. So we still have, obviously, there's the COVID stuff. It's hard to get an appointment. Even if you could get a visa, you might not be able to come in. And then there's just how it's going to be implemented. This just came out in the last week, I guess. And so we don't have data to know how it's working. We don't know how it's going to work. We imagine it's going to be inconsistently applied from consulate to consulate. There's still an issue of then entering the US, even after you have the visa, so working with the border officers. So there's still a lot of unknowns about how it's going to work in practice, but at least it appears that at the State Department, there are some reasonable people who understand the importance of the work that's being done and needs to continue to happen in the US.
Okay, sounds good, great. And we have questions coming in, but we wanted to, I just wanted to kind of frame this before we get into more of the detailed questions and answers. So we have this proclamation. It has the full force and weight of the law. And we've seen that this proclamation, which has these immigration restrictions, it changed from April until June. It got more restrictive. And as we're now sort of under the existing proclamation, I think a sort of foundational question is how long is this going to be in effect? When does it expire? And what are the prospects of it continuing in the future? And so I'd like to ask Keith Pabian if he wanted to kick off that conversation.
Yeah, so there's a lot to this. So I'll talk about the proclamation first and then go from there. So good morning, everyone. But in terms of the proclamation itself, in the actual order, it instructed the agencies that administer immigration, which is basically Homeland Security and so on, Department of State, to review the order within 30 days, the proclamation within 30 days, which was actually July 24th, and then every 60 days after that. When we talk about that, there's a few different areas where this could change. Number one is the agencies could come back and say, you know what, we want to change some things when they're looking at this. And I think there are certain visa types like the L1 that I think has a better chance of coming off than an H1B, where the H1B has been targeted by not only this administration, but by others where they've claimed abuse and so on of the H1B program, whereas L1s are used by some of the largest companies in the United States to move executives and managers into the United States. There's also a lot of lobbying efforts underway which go hand in hand with that, as well as some lawsuits. It took a little while, a lot longer than I would have liked, but there's finally a couple of lawsuits pending. A bunch of H-1B visa holders filed essentially a class action, and the U.S. Chamber of Commerce joined them over the weekend, which is good. So that's happening. In the meantime, there's other stuff too, kind of going into what Bennett and Rhonda were saying. There's so much more to this than just the proclamation, and I just want to quickly touch on that because I think it kind of frames a lot of this as we open up our discussion into whether we think that this could expire, or that this could go on past December 31st. Because in the proclamation, it's currently slated to go all the way through the end of the year. Number one is, there's been a lot of talk about student visas in the news, especially in New England, where you have a bunch of the colleges that sued the government, and they quickly backtracked. Although quietly, I was amazed at how little press this got over the weekend. Immigration and Customs Enforcement announced that incoming freshmen are not going to be able to come if their schools are fully remote. That goes hand in hand with first of all, the power of the administration to exclude people that aren't here, which is really what we're talking about, as well as for the industry itself, for the life sciences industry. I think there's a huge danger of attrition of talent right now. You have student visa holders that don't feel so welcome here or are not welcome here. We have these proclamations and these announcements coming out that are very anti-immigration, anti-foreign national. And I've seen firsthand organizations of ours, clients of ours, moving jobs to other countries because there's so much, other countries have so much more progressive immigration laws. I'm hearing about students that are choosing other countries rather than coming to the United States for their studies. They don't feel welcome here. And I think that there's a real danger right now of what is a job market going to look like in a year, 5 years, 10 years, 15 years, because we're definitely losing people. And that's a real danger where during COVID, I think the unemployment rate in the life sciences industry actually went down, despite high unemployment massively in other industries. In the meantime, in terms of the election, and I think going back to Dan's question, I think this is a good segue into that. I've been doing a lot of talking, as I'm sure Rhonda and Bennett have as well, about the proclamation. And so I'm starting to get a lot of questions about the election. And so I went onto the two campaign websites, the Trump administration and Biden's website. When you go onto the Trump administration's website, there's absolutely no specifics about what the future might hold. What it does, it kind of talks a lot more about restrictions and enforcement. I think what really stood out to me is the biggest piece on the page was a picture of a border officer in a bulletproof vest standing in front of the wall. Essentially, we're in it for more of the same and probably even more restrictions if Trump gets reelected. In terms of Biden, it was almost a 180. Very pro-immigration. His first line of the whole thing is that he wants to roll back all these Trump-era restrictions. He even talks about some further immigration avenues, and he actually, on his page, talks about the importance of foreign nationals to companies, organizations, employers in the United States. So in terms of that, and we were talking about this prior to actually doing this panel. I think it might be helpful to hear in terms of what we think. In terms of one of the biggest questions I'm getting is, can this go past December 31st? And so if Biden gets, so this is my take, and then I'll stop talking. But in terms of if Biden gets elected, I don't see it happen. I think Biden's going to let this expire and just move past this and hopefully try to further some other changes as well, especially if the Senate flips to Democrat. In terms of Trump, I think this could just be the beginning. In the proclamation, he talked a lot about further changes to H-1Bs and the perm green card route for EB2 and EB3, those categories. And I think those might be coming. The good news is, and I've heard this from a lot of people that deal with politics and lobbying and so on, the closer we get to the election, the harder it's going to be for Trump to change things. And I've heard that if he doesn't get reelected, it's very difficult for a president to effect changes in that transition period, basically between November to January. So, I don't want to get too into politics, but from this standpoint, if Biden gets elected, I think we could see some positive changes coming. If Trump gets reelected, I think one of the biggest challenges, if he tries to extend it beyond December 31st, is a lawsuit could claim that he's trying to effectively change immigration laws, which he can't do by himself. That's what Congress is there for. So I think it might be a hard ask, but I'm not saying he wouldn't try.
So if I could just follow up on a couple of points, since I think that is the big question. And as Keith has talked to lots of people, and I have as well, I like to remind people that, when it comes to immigration, what happens in November is so much more important than anything COVID related. These COVID related restrictions and things are gonna hopefully go away sooner than later, but they will at some point go away. Whereas if Trump gets reelected, we're gonna have a huge problem for the next 4 years. And so whether the proclamation gets extended or not, if Trump gets reelected, is really not gonna be all that important, because then they have 4 years to change the regulations and make restrictions much worse for everybody, both inside and outside of the US. So to Keith's point, right now, there probably isn't enough time to do that regulatory change because of the way that the process works. But certainly if he's reelected, 4 years is more than enough time to restrict everything, to make these proclamations look like very small drops in the bucket in terms of immigration restrictions. And so if Trump gets reelected, we're going to see a huge problem with trying to get any talent, whether it's inside the US or outside the US, hired by anybody. It's basically going back to what they think is going to be their policy to win the election, right? I mean, Trump has been build the wall all along. And so he thinks that these restrictions, and by the way, these proclamations have more to do with his reelection strategy than any actual significant effect or impact that makes any sense for any legal or scientific purposes. So he thinks that's a winning strategy. Interestingly, as Keith mentioned, Biden thinks pro-immigration reform is a winning strategy. So we're going to find out in November who's right.
Well, and I think also just another layer of that is the idea that in addition to the ability to disrupt legal immigration through proclamations and through regulation, the Trump administration has systematically disrupted the process through delays and through cutting off any forms of communication between attorneys and the government, between inconsistent adjudications, all of the ways in which they can make the process impossible to maneuver through and impossible to plan people's workforce around to know how long something is going to take. So I think that those kinds of disruptions, COVID is a perfect cover for that. So we're certainly seeing that, just go skyrocket, cases falling off of the map and no way for us to figure out what's happening or push them through. There are potential furloughs of the USCIS workers coming, not the end of August maybe, but and I think that can continue with COVID as the cover, certainly through the election. So even if they're not able to make any other regulatory changes between now and then, they can still make it pretty difficult for everybody. And if nothing else, I would expect if Biden were to be elected, even if we don't see any positive reform, we can at least see maybe some good governance come back and some predictability and good process.
So it sounds like, to summarize, elections certainly have consequences, and with respect to especially the presidential election, and with respect to this particular policy, since it's a proclamation that's fully within the discretion of the president, it could have a rather immediate effect. If Joe Biden is elected as president, what I'm hearing from the panel is that you anticipate that this will be withdrawn or actually not renewed because it's set to expire in that window of time of transition between administrations. But if the President Trump is reelected, then at a minimum, what I'm hearing is that, and again, we're not, prognosticators here, but is that you would anticipate that these restrictions will continue, if not be added on. Is that correct? Okay, so for other business owners in the community, this is something that, in addition to all the other changes that would take, issues that come up in a presidential election, this particular one, is at play. And does anyone on the panel, how can the members of the community sort of track this? If there's any changes, because I understand that the proclamation can be modified, in advance. I would imagine maybe it won't based on this conversation, but is there anything that members can do to sort of track this issue? Is there any website or other resource that members can do? Obviously they can call you, but if there's any other way to track this,
Yeah, I'll start and then others can jump in, but the American Immigration Lawyers Association, or AILA, AILA.org, is the leading organization for immigration lawyers in the United States. We have about 17,000 members, and so they are front and center in all these issues. In fact, they are testifying today in front of the Senate about USCIS's request for funding based on the fact that they made themselves a mess and now are running out of money due to mismanagement of their funding and application process that Rhonda talked about a little bit. But AILA.org is the place to go for frequent updates, daily, multiple updates every day on what's going on with all of this, because they also have a lobbying arm through a sister organization and get direct updates from the Congress people as well.
Rhonda, do you want to go?
I think that yes, that's a good organization. There's NAFSA, which also can provide updates for people. NAFSA, and I say that, and now I'm not sure what it stands for.
National Association for Foreign Student Advisors.
There you go. I was like, just drew a blank there. But it is true that it's with all of the different layers of restrictions right now, if there's a specific scenario, fact pattern that there are questions about, you're going to have to reach out to a professional to find out, because there are just way too many things and layers of restrictions to be able to know really what someone's options are. If you're looking at specifics, it's best to reach out to somebody.
Yeah, and the organization that Bennett was mentioning with the sister agency is the American Immigration Council. And so I follow both AILA and the American Immigration Council on social media, because they're pretty good at getting the word out. The other thing is, just on this front, the Trump administration is putting out so much with immigration. They're doing so much. And a lot of it doesn't necessarily affect the life sciences industry. But what I've been saying to a lot of people is just, it's exhausting and it's tiring, and it's can feel overwhelming. When you are feeling like you are not getting what you need, and it's affecting your organization, reach out, get the story out. It's just, I'm sure Rhonda and Bennett feel the same way. It's been a hard 3.5 years at this point, and it's hard to keep the fight going. But I think it's more important than ever, because they're definitely trying to push through things almost on a daily basis at this point.
And that's one of their strategies, is to overwhelm everybody and to make people stop fighting back.
Yep.
We have a few minutes left here, and we've got some questions that are pouring in. I'd like to pose some of these questions to the panel. We have one question that is an H-1B visa from an academic or nonprofit transferable to a company or corporation?
Unfortunately, the answer to that is no. In most circumstances, no. Because someone with an H-1B that's from a CAP exempt organization, an academic H, it's kind of known as, they did not go through the lottery process, so they were never counted. They were never counted against the numerical limitation on the H-1B. So now when they want to move to a for-profit company, that company would have to go through the lottery process with them. And because of the timing of that, it ends up being a company is petitioning for a potential worker 6 months in advance of when they would be able to start with them. So usually that's not possible unless there can be some sort of the employee can continue to work for both organizations. That's a loophole for concurrent employment. But in general, people who are on academic H's can get stuck there unless they're eligible for something else, like an O1 or some other kind of visa.
And just to be clear, we should say that has nothing to do with the proclamation or COVID restrictions. That was the law long before.
Yeah,
yeah,
that's just the rule.
Okay, another question is there a risk that an L1A at the end of the 7-year period who wants to move into an L1 commuter, is there a risk that may be denied?
So I guess I would say it depends on a couple of things. If they already had a visa, they're exempt from the proclamation by having the visa. So it depends on where they are in the process. There's a 7-year limit on L1A status. So when you talk about commuter, I think they're probably talking about an intermittent L1A status, which means you've been in the U.S., you are in the U.S. less than 50% of the time. But if you're not, then you're not eligible for that status. So if you've hit your 7-year limit, you cannot get a 50% intermittent L1 unless you've been outside the U.S. for a year after that to reset the clock. So there's a lot going on here. Again, none of which has to do with the proclamations or COVID.
Yeah, but if it does have to do with the proclamation, it's just a matter of luck. Were they in or out of the U.S. on June 24th?
Correct.
It comes down to that, really. If they were out and didn't have a visa, then they have to be eligible for an exception. But if they happen to be in on that day, then they're not subject to the proclamation. I mean, that's how capricious this is, really.
Okay, going back to the previous question about transfers from academia to industry. The answer I heard was that that's not a possibility. What are the other possibilities for companies to hire internationals apart from O1? What other options are there?
Oh, I think it's my turn. So, other than that, it's the visa types that Rhonda and Bennett were saying aren't covered by the proclamation, which essentially all fall under treaties. It's either the E1 or E2, which is this weird, complex visa that's so fact specific. And then there's the TN for Canadians and Mexicans, E3 for Australians, and H1B ones for Chilean and Singapore nationals. Outside of that, that's really it.
Yeah, and then the O1 and the J1 research scholar that we mentioned before. That's the kind of universe there.
Yeah, the hard part is the immigration system from the start, taking out anything that President Trump has done or anything that COVID's done. There's just not that many visa options out there. It sounds like there's so many, but so many of them are so fact specific that you have to kind of just make sure it just only applies to certain situations or certain nationalities or people. So when the Trump administration essentially takes away 3 of the most common visas with H1Bs, L1s, and J1s, there's not much left.
So obviously there's, and Keith, you had talked about there being now, throughout this administration, so many challenges, and you expressed that, I'm sure you're sharing what your clients are expressing is frustration and maybe exhaustion as to how to handle all these. And I know the topic of this discussion has to do specifically with the proclamation, but I guess as a general matter, which I think would be useful for our audience, what are the number one sort of questions that come up? The top 2, maybe 1, 2, 3 questions, hot issues that come up that each of you have feel maybe more regularly than not.
I'm getting endless questions about travel. I mean, that's the biggest one. And that's where I know that we've talked a lot about how this proclamation sounds so big, but in reality, the COVID restrictions are so much worse and so much more impactful. An example I give is if someone is traveling from their home country, connecting through another country because they can't get a direct flight to the US, and then flying to the US, and then maybe they need to travel to a different state once they get here, they're having to deal with 3 different countries, travel issues, restrictions, as well as state to state quarantine and travel restrictions. And that's not even trying to figure out if the flight is going to get canceled or not. So as well as if the person even has a visa in their passport and if they can get a consulate appointment, which we're just starting to get those now. So I think travel is the biggest. I think the second one is just this confusion about the proclamation that applies to foreign nationals, as well as just this fear of what's next, and the foreign nationals just feeling like, what else am I going to have to deal with, and what are they coming for me, right? Like kind of like making it personal with just them feeling like they're at the end of their rope.
Yeah, and I'll just add to that, because I think I agree completely with what Keith said. And because of that fear of what's coming next, we've seen an acceleration of green card cases from employers, because the foreign nationals are understandably concerned that there's going to be another restriction coming down the road that is going to hurt them or limit their ability to either be here or work here or stay here. And so what we're seeing is employers reaching out sooner than they otherwise would to start the green card process for their existing employees, to provide them some protection and assurances that they're hopefully going to be able to stay here for the long term.
So just the last additional point I wanted to mention is we have also seen a lot of people who are stuck outside the US and then wondering what their options are. So just being able for employers and employees to know that if they're outside the US, they can work remotely full-time from outside the US. They are no longer under the jurisdiction of US immigration, so they don't have to actually have an approved petition or a visa stamp or anything like that to work remotely from outside the US. Now, there are other implications, tax implications, payroll implications, things like that, workers' comp, all of those other kinds of issues. But from an immigration perspective solely, they can work remotely. People can work remotely from outside the US without the need for any kind of work authorization or approval from immigration.
And Rhonda's talking about in their home country, right? Because obviously if they're in a third country, then there could be immigration issues in that country.
Right, from US immigration, right? From
Right.
US immigration, they can be anywhere as long as they're not in the US, right? But and then you just, yes, you have to figure out all of the other pieces of that puzzle to make that work for them. But from a US perspective, it doesn't, if they're not in the US, we don't care.
Right.
So we're wrapping up here. I want to sincerely thank our panelists, Rhonda, Bennett, and Keith. We're all going to be watching the election very closely for many reasons, and now in particular with respect to this issue. I think you've done a great service to the MassBio community to provide the current state of play. And if things happen in a certain direction and the restrictions get worse, I'm sure that you're going to be an incredible resource for the MassBio community, and maybe we'll have to circle back. I know many of us don't want to have to cross that bridge, but in any case, it's really helpful, and we really appreciate your time. We also appreciate the time of our members, MassBio members, and everyone's got things to do and meetings to attend, and I think that will conclude our today's webinar. Thank you so much.
Thank you.
Thank you. All right.